Good morning, class. Today we start on chapter 6 and we will be discussing legal issues affecting an entrepreneur. Some of the legal issues that could impact an entrepreneur are copyrights, patents, licensing, trademarks, and more. And the thing to remember is that with everything else, the entrepreneur might make decisions on his own or based on his mentors or his support network's input. However, when it comes to legal issues, one thing to remember is that legal advice needs to come from an attorney. So in this chapter, we are going to be focusing on intellectual property decisions, and we'll be talking about contracts, insurance, liability. Now, we start with intellectual property. Intellectual property includes patents, trademarks, copyrights, and trade secrets. When you think about it, all of the intellectual property are assets to the entrepreneur. Because entrepreneurs often don't understand intellectual property, sometimes they might ignore steps that need to be taken in order to protect their assets. So for that, what do we need? We need a lawyer. The question is, how do we select a lawyer? When you think about lawyers, you need to not only just get a lawyer, but you need to get a lawyer that focuses specifically on intellectual property. Now, lawyers, they will tell you what their fees are in advance. If you ever have to hire a lawyer, you can call a lawyer based on recommendations. You can just call up their office, figure out what is their consultation fee. They usually have a 30-minute or an hour consultation fee. And it is a good idea to do this in person because you'll get a sense of how they will get along with you, how they will treat you, how the office works, and all of that. So when you think about hiring a lawyer, you need to think that this is going to be possibly a relationship that is not just transactional, right? It's just that it doesn't happen on a one time you purchase something and it's done. You might need that same lawyer for something else in the future. So you just need to make sure that you are convinced that this is the lawyer that you want. One thing is lawyers are expensive. So if you don't have the money, some lawyers may be open to purchasing or to receiving some options or some stock from your company. But if that's the case, just be sure that it's very clear as to what you're offering. Let's talk about some of the legal issues in setting up the organization to begin with. Since there are many options in setting up an organization, you will need to understand what are the advantages and the disadvantages of each one. So legal advice is necessary to ensure that you're making the right decisions along the way. So let's talk about patents. A patent is a contract. We've already talked a little bit about this, but it's a contract between the government and the inventor. So the government will grant you, the inventor, exclusivity for a specified amount of time, and that can work in your advantage. We've talked about what the advantages would be of having this and how it could protect you from competitors. At the end of this specified time, the government publishes the invention and then it becomes part of the public domain. So at this point, I'll show you a short video on patents.
The government grants the property right in exchange for disclosure of the invention. It's like a quid pro quo. In the United States, we will give you this amount of time to have exclusive rights to your invention, to keep others from making, using, selling, or importing it. And in return, you're going to give us a nice little detailed way of how to make your product, or what it's made of, or how to use it, however you claim your invention. In the United States, a patent is a property right granted by the government to an inventor. As I indicated earlier, it gives you the right to exclude others from making, using, selling, offering for sale your invention throughout the United States, or importing. something that could be your invention counterfeit-wise, kind of like when I was talking about branding and trademarks, into the United States for a limited time, and then you have to tell us how you did it. There are 3 types of patents. There's the utility patent, which is a new and useful process, machine, article of manufacture, or composition of matter, or any useful improvement thereof. So when we're talking about a utility patent, we're talking about, let's suppose, the chairs that you're sitting in, how to make those chairs, the materials that go into those chairs. Those would be utility patents. A design patent, on the other hand, goes to how something looks. So again, using the example of your chair, it's not how it's made or what goes into it, it's how it looks. So it goes to the design. It's an ornamental type of patent. And then a plant patent is whoever invents or discovers and asexually produces any distinct and new variety of plant. Many may think, oh, well, this is like just flowers along those lines, but it's actually deeper than that. How many of y'all like potatoes? I like mashed potatoes, fried potatoes, sliced potatoes. I mean, I'm sorry, I'm having a moment here with potatoes because I like potatoes a lot. But if anybody knows, potatoes are root vegetables, correct? And they can be very, very sensitive to ground temperatures. So if there was a potato brand that was invented asexually, that kind of, it wasn't as sensitive to ground temperatures, that could potentially be a plant patent. So in the role of the patent system, it's used to protect inventions, encourage innovation, promote commercialization, and the application of the invention. Basically, when you put your patent out your invention out to the world and it gets patented, someone's going to look at it and say, I could do that better. I mean, I'm just being honest. You will get your exclusivity. It will take them time in order to improve or what have you, but it encourages innovation. Think about it. How many times have you seen something and you're like, I could do that better. I could make it faster. I could make it smaller. And then you're like, oh, there's a patent on it. Let me go look at the patent. Okay, this is the process of making it, or these are the materials. I can use biodegradable materials that's gonna be cheaper, and the overall net effect will be cheaper. That's what patents do. They help to encourage innovation and commercialization. So why should you get one? It will help you gain entry into and deter others from entering a particular market. Patents are like property. You can use it to attract inventors. It can be used as a marketing tool. How many times have you seen patent pending? Or we have a patented invention. When you hear that, you think, oh, well, if they have a patented invention, that's something that's not necessarily out there, right? So you're like, ooh, let me go try that because this is unique. It can be inserted against an infringer. So if someone tries to use your invention, you take your patent and say, ha, ha, ha. No, you cannot. I have a patent on it, and it's still enforceable. It can be used as collateral. Like I said, it's property. And it can create revenue because people will believe and people will see that you have a patented invention, so your invention is unique. And they would want to buy into your company potentially. Who can apply? Those that invented the invention. Assignees are obligated assignees. So if somebody funded your research, funded you being able to make the invention, and you said, okay, I will give you a partial stake in this or a whole stake, and a person with sufficient proprietary interest that runs similarly along the same lines. Once you get your patent, you can license it so that others can use it and you get royalties back off that licensing. You can enforce it. You use it yourself and you use it to keep others from being able to use your invention. You can use it as a basis to be more innovative and create more competition. Or you can sell it. You don't have to keep it. Some people get patents and they decide they don't want to go into that market and they decide to sell their patented invention.
One thing that the USPTO has done is they've established partnerships and cooperation with other offices. So that makes it easier for you to do a search to make sure that there aren't other patents already approved on your invention. As an example, the Global Dossier is a one-stop access for application. So you can apply in other offices as well. Because when you apply for a patent here, you're only applying to the US. There is a process that you would have to follow in order to get your application. The application is divided into sections. First is the introduction, the description of the invention, claims, and then you need to sign your application. At that point, your patent becomes pending. Obviously, because the patent is a protection of your invention, this applies to everyone. Therefore, you could not infringe on someone else's patent. One thing that was new to the USPTO was the business method patents. So when the internet came along, Amazon.com and Priceland.com applied for business method patents. Now, there is a controversy on business method patents as to whether it's possible to patent a business method or not. The truth is that it would be harder to apply for a business method patent because it has to be very clear that it is a departure of the way that business used to be run before.
Yes, you can. There's some debate about that. The patent rules say that you cannot patent a method of doing business, but the test for patentability is that whatever it is you've invented must be a useful, new, non-obvious improvement on pre-existing technology. So anything that meets those three criteria is patentable, including business method patents, software that works with machines to solve a medical problem of some sort, for example, is patentable.
Now let's talk about trademarks. Trademarks, we've all seen them. It could be a word, it could be a symbol like the Nike symbol, or it could be a design combination that identifies a specific company. So let me show you a little clip on trademarks.
You're supposed to be able to look at a trademark and recognize the source of goods or the service that's associated thereto. So when you're thinking about your branding, if you haven't already done your trademark, that's kind of like how you want to think about it. What is my mark conveying about my service or good? Is anybody that looks at it going to recognize that when they see this mark, it's my product or it's my service? And while you don't have to register your trademark, we really encourage that you do so because it gives you the right to enforce nationally and bring legal action into federal courts if someone tries to use your mark. Okay? You're able to use the federal trademark registration symbol, which is the R with the little circle. You can register your mark with customs, which is awesome. How many are familiar with Canal Street in New York? So what happens on Canal Street? For those that know, somebody will come up to you and say, hey, fake bags, yes. Would you like a Coach? Would you like a Prada? Would you like such and such? And they take you somewhere. And they say, okay, well, what type of bag do you want? And they'll pull out this symbol from a little piece of plastic and slap it on. Okay, so how do I know? Yeah, I saw it, but I didn't buy. Because that's counterfeit goods, right? So they're cracking down on this. New York has been heavy on cracking down in other ports to keep people's trademarked goods from being counterfeited. When you register, you help them do that. It also serves as a basis for foreign filing if you want to register your trademark in any other country. And it is published in the US trademark database, which puts people on notice that that mark is in use. So trademarks can be words, such as Starbucks, can be designs. Everybody knows. I'm still trying to figure out, is that a mermaid or a lady holding fish? But everybody knows when they see that, that means you're talking about Starbucks. Can anybody think of any other like popular designs? Target, yes. Nike, the swoosh, right? Target, and the bullet sign. One of the things also about trademarks you need to recognize, trademarks can also be colors. Now, ladies, if you were to receive a robin blue egg box, colored box, would you be happy? And why is that? Tiffany's. Gentlemen, are you paying attention? They can also be smells. How many of you remember those plastic shoes from the 80s? Jellies. It might have been a jelly, it might not have been. But some of them had a scent to it. That scent, that bubblegum scent, was associated with a particular brand of those plastic shoes that all little girls wanted. I will raise my hand. I wanted them too, but my parents said no. They make your feet sweaty and stinky, so we're not buying them. But there was a smell associated with one of those brands, and that was trademark. So think outside the box. Don't think necessarily it has to be necessarily a word or design. It could also be representative by a color or a smell.
Why is it good to have a trademark? The main thing is that it establishes your rights regarding the commercial use of said mark. And of course, this is good for marketing because then people can recognize you. Of course, there are other benefits that you can see on your screen, but that's the main one. Let's talk about copyrights. Copyrights are really important when it comes to original works of authorship. So we're talking about writing, books, and music, and so on.
When it comes to copyrights protect original works of authorship, including literary, dramatic, musical, artistic, and other works fixed in a tangible medium. The thing you need to remember is it needs to be fixed in a tangible medium. Now, are copyrights examined here at the Patent and Trademark Office? No. Oh, say, look at the slides, It's at the Library of Congress. That's where copyrights are administered with their registration. The USPTO advises the executive branch on IP issues, including copyright, but the copyrights are not taken care of here. That's at the Library of Congress. Realize that as soon as you put something in a tangible medium, when you wrote it, you drew it, you're an artist, you're a sculptor, it's automatically copywritten, okay? You can use the little C symbol on your works. So you're like, well, why should I register it? You should always register your copyright registration, which compared to a trademark and a patent is inexpensive, seriously inexpensive, because it helps you to better protect your copyright, okay? Here are some examples of things that can be copywritten. And I'm gonna give an example of why you'd wanna register, all right? How many are familiar with Marvin Gaye? I remember when he passed, my mom made me play his records all day long. Yes, I said records. And you're like, well, that's not, for those that don't deal with record players. Yes, I had to be the one to flip it from side A to side B and make sure that the needle didn't scratch something up when he passed away. Marvin Gaye's been gone for over 30 years. However, there have been several court cases due to copyright infringement from other musical artists that his estate has brought against them, and they have won. So when you look at that life plus 70 years, you may think, oh, that's not much of anything, but think about the millions that his estate is getting in fees due to that infringement. So if you have something that you think is valuable, well, anything you do and create is valuable, correct? Because it's yours. Make sure that you protect it, because it's not only for you, but your future generations may be able to make sure that they get something from that as well.
Since we're talking about copyrights, patents, and so on, those are ways that you have to protect your business. Another way would be trade secrets. An example would be Coke. Coca-Cola has a trade secret of what they put into Coca-Cola that they have kept for perhaps over a century. Other companies that have kept trade secrets are KFC and Krispy Kreme donuts, and of course, several of the aviation companies. Anytime that they have discussed about the composition of Coca-Cola or the recipe for KFC and everything, they surely have made the other individuals sign a non-disclosure agreement, otherwise known as NDA. Also, you can make your employees sign a non-competition agreements, because once they are in your company, they will learn several things that they can later use to compete with you, unless you make them sign a non-competition agreement. Now, what are some of the things that you can do to maintain secrecy? Of course, make sure that you're filing everything in a secured location. Make sure that you are debriefing your departing employees so that they remember that they have signed an NDA and a non-compete, reminding your employees and yourself to not discuss your trade secrets in public. Now, if somebody on their own reverse engineers your product, or they come up with a similar recipe, then there's nothing that you can do about that. However, some of the things that you see on the slide are important for you to maintain your secret. Now, let's say that you have a patent, copyright, or a trademark. You could license it to another company for a royalty fee. And that's a good marketing strategy, and it could increase their revenues without the risk. It could be a way to start a new venture. You just need to make sure, again, that any contract that you sign in regards to your licensing is very clear and enforceable.
Can you just break down licensing a little bit more for us? Let me walk through the hypothetical, what I've heard a lot over the last 2 days. I've worked super hard. I finally got my patent through the USPTO. I have this great document signed by Director Yanku. There's a gold seal on it. Can I just bring it to a company and then get a check for 20 years? I mean, how does it work?
If it were that simple. In effect, though, yes, that's what the goal is. So licensing, really simple. It's a transaction where you take the rights under that patent. That patent grants you the exclusive rights to make, use, or sell the products based on your invention. But because it's intellectual property, you own the property rights. And just like you could sell or buy or sell or lease real property, you can do the same with intellectual property. So a license is essentially like a lease of real property. A license, you grant the rights in that intellectual property, your invention, to another company. They'll make and sell the product. And what do you want in return? You want the rent, or you want the royalty. So that contract, it's a written agreement usually, is a license agreement where you're granting rights to a company to make and sell the products based on that invention. So I met a nice young lady, I think her name was Lori, had a great invention. She doesn't want to make and sell that product. She wants a company bigger than hers to take that invention to Walmart, or she mentioned Bed Bath & Beyond. So we know companies that make and sell similar products. They have the production sources overseas. They have the relationship with Walmart and Bed Bath & Beyond. They will pay her a percentage of every dollar that they make for the right to sell that invention. The hard part, making sure you find the right company that's willing to do that and you make the right deal.
Let me just ask you a quick follow-up. Yesterday we heard a great panel. Howie moderated the panel. We heard about an inventor. He had an idea. He went on a show, and they paid him $3 million. And they went their separate ways. Is it ever possible to sell your patent to a company?
Sure. And the same analogy, I said with real property, you could lease it or you could sell it. And I think you're referring to the Moki doorstep. So really interesting. He actually had sold his patent, but then Damon John and his group together licensed that patent to another company that's actually paying Damon's group now the royalty. And hopefully he's still participating in that. But
And I think Ray wants to.
Yeah, I'll just add on that. Remember, with licensing and everything, you could have an exclusive license or a non-exclusive license. All right? Most of the time, you're going to be dealing with people with exclusive license. They want the whole thing. They want the complete rights to it. That should come at a premium.
Another legal issue that could pop up for entrepreneurs would be product safety and liability. In the United States, the Consumer Product Safety Act created a commission that describes the safety standards that companies need to follow for products. This is to protect consumers. It stipulates that any products that are deemed unsafe need to be recalled. Additionally, certificates of compliance are required to be issued for the import, distribution, or sale of regulated consumer products by the manufacturers here in the United States. These certificates of compliance, of course, need to attest that they are compliant to CPSC or Consumer Product Safety Commission requirements. They need to include the description, when and where the product was made, how it was tested, who maintains testing records, and so on. Regarding insurance, the entrepreneur should consider purchasing insurance in the event that problems occur. Regarding insurance, one hopes that you won't need to use it, but if you ever need it, it is invaluable. So it's definitely one of those costs that are well worth it. Regarding what type of insurance to get, here in the book, they list some of the types of insurance that you would want to consider, depending, of course, on the type of business that you own. Property, we're talking about fire insurance, burglary, any business interruption, casualty, in case there are any judgments obtained against the company, vehicle liability, if some of your employees are driving your company cars, life insurance, workers' compensation, and bonding. So total insurance costs are one of the lines that should be represented in your business case. For each one of these types of insurance, you'll need to do your research for your business. Advice and information on this type of insurance is available at the Small Business Administration. So moving on to the Sarbanes-Oxley Act. This act came to prevent insiders or employees of companies, particularly CEOs, to prevent them from defrauding the public. And here's a little bit of a backstory on this act.
The energy conglomerate Enron was the 7th largest company in the United States, and then, poof, it collapsed. Finance ultimately is about trust. Enron's management had frankly cooked the books, concealed problems in the business, defrauded investors, and more. Its failure wiped out more than $2 billion in retirement savings, tens of thousands of jobs. This scandal was followed by yet other multi-billion-dollar accounting frauds at WorldCom and elsewhere. And so, in response to this crisis, 20 years ago this July, Congress enacted the Sarbanes-Oxley Act. I was honored to have a front row seat working with my hometown Senator Paul Sarbanes on this bill. And a central goal of Sarbanes-Oxley was, again, to restore that trust in our financial system. So first, it enhanced the quality of auditing standards, inspections, and enforcement. Auditing standards, for instance, were set by a professional association, and the profession was writing its own rules. That's an inherent conflict. Thus, Sarbanes-Oxley established an independently funded auditing standards setter, the Public Company Accounting Oversight Board under the regulatory oversight of the Securities and Exchange Commission. It also ensured that the accounting standards themselves, the setter, the Financial Accounting Standards Board, had secure independent funding. You see, it matters who audits the auditors. Second, at Enron, their auditing firm had lucrative consulting engagements with the energy company. So that's an inherent conflict as well. Thus, Senator Sarbanes, working with Congressman Mike Oxley on the other side, worked to create a stronger barrier between auditors and other parts of the auditing firm's businesses. And then lastly, the Enron crisis revealed problems with how companies are governed. So, Sarbanes-Oxley established requirements to help ensure that the incentives of executives, their boards, their auditors, their accountants, their audit committees are better aligned with their investors for the protection of you. So, happy birthday, Sarbanes-Oxley. In the last 20 years, we've learned a lot. The quality of public company audits has improved. Let's not forget our core lessons, though. It's important to have robust, independent organizations setting the standards, inspecting the firms, enforcing against those rules. It's important to separate the parts of an auditing firm from its consulting services that may have conflicts with each other. And it's important that companies are held accountable for their numbers. When trust in our markets grows, that benefits investors and issuers alike.
So, what implications does the Sarbanes-Oxley Act have on entrepreneurs? Well, you as the CEO of your company will be required to vouch for your financial statements. So you're signing that these books are true. Also, when you are setting up your company, you need to make sure that there aren't any conflicts of interest, specifically dealing with auditing. Lastly, you might want to think about setting up a board of advisors rather than a board of directors, because a board of advisors will be considered to be more independent. Another thing that you can do to protect your business is to be very careful with contracts. Why? Because a contract is legally enforceable, and so therefore you should not be relying on a handshake, or if you have any transactions that are over $500, for sure you need to have a written contract. Lastly, any deal that has to do with real estate must be in writing. What do you do to protect yourself? Make sure that you understand what the contract is saying. Every single clause of the contract, you should understand what it means. If there is something that you don't agree with, you can just cross that out and make sure that there aren't any spaces. Make sure that if there are spaces, you cross those out, because the last thing that you would want is to have somebody add a clause after you have signed it. And make sure that you have a copy for your files right after signing. So a contract has some conditions that both parties have to agree on and they have to abide by. An example of contract conditions would be an offer of employment, where an offer is made. If somebody offers you a job, it's not legally binding until it has been written and the person has accepted the offer. Something is being exchanged. Both parties are competent, and of course they have to have the right to negotiate for your firms. Any illegal activities under a contract are not binding. Now let's talk about contract breach. There are several types of breach that could occur, and breach of course has consequences, not the least of which is that you might have to pay, or the other party might have to pay. Having said that, there is this referred to as contract restitution, where if one of the parties fails to live up to their contract, The other one may also agree to drop it. And in that case, you have what is called contract restitution. And with that, we've come to the end. We've talked about several things that you can do to protect your business. And if you have any questions about any of the topics we've covered, make sure that you reach out to me. I'll be more than happy to help. Okay, guys, that's it for this week. I'll see you in the next video. Until next time, bye.